papers and read those documents. You know, having served in law enforcement for 38 years and working with the Federal Government on numerous cases, OCDF cases also, I'm surprised at what I read. I'm surprised that those cases moved forward or as long as they did and continue to do that up until the point where Agent Terry was tragically killed, murdered, along with, like you said, almost 300 Mexican citizens.
Perhaps countless numbers we won't know.
You know, every time in law enforcement, I was chief law enforcement officer for a county. Mr. Holder is chief law enforcement officer for the United States of America. But every time I was presented with a subpoena, unless I went to court to try to quash the subpoena, I had to comply. And I understand the limitations. I understand blacking out specific things in regards to operations, in regards to investigative procedures or techniques. But at the end of the day, I don't understand, I really don't understand why the Attorney General, who I believe probably didn't know anything about this, why he would be so reticent in regards to releasing information that would clearly show that he didn't know. Particularly with all the information that was going on at the time and all the hoopla that was going on at the time in regards to guns leaving America and being utilized in Mexico to keep the drug cartel moving. It's hard for me to understand how it never reached past just Phoenix. Having dealt with the Federal Government on a number of cases, on drug cases, working with DEA, FBI, ICE, and others, wiretap cases, I'm surprised in reading the affidavits that it didn't move further, at least how it didn't move further. And I guess the biggest question is, obviously, the letter that received on February 4th that claimed there was no gun walking going on, and correct me if I'm wrong, it was 10 months before Justice corrected that assumption.
That's correct.
Do we ever get a reason why it took 10 months before they ever made the confession that, hey, guess what, that memo is incorrect?
That's essentially the reason we're here with contempt, is that those documents we request, a substantial portion of them would be exactly right on that question of between February 4th and December, who knew, what were they talking about, and why when people we believe were saying this is factually incorrect, this is untrue, why that never bubbled back up to us. We do have at least one piece of information that shows as early as August, they were in a position in which they apparently knew that this was false, straight false, and it wasn't until a few weeks before December that they began working on the operatives for how they walked back from this. We have indications that they were considering walking back only from a portion of it, rather than, and I think it's Stephen Weiss, if I remember, who said, no, we got to do it all. We got to do the right thing. And, you know, there are people that did the right thing in this process, but may have been delayed by 5 or 6 months from the time they knew. And there are people who obviously knew the right thing and were officers of the court and did not come forward. It is part of our investigation, but you hit on something that I think is equally important. You've looked at a lot of wiretaps over the years. We believe, as part of where we have to get at the end of this investigation, we believe that the fundamental rules for actual accountability of reading and understanding, not a summary page, but a wiretap, of coordinating OCDF so that you understand what some parts of it know and some don't, so that one person becomes accountable for the overall operation, that's lacking, at least in ATF and apparently in all of justice. And that's the reason that even after we do what's right for accountability for the Terry family, we're going to have to present a series of reforms, hopefully ones that will be instituted primarily by the Justice itself, to make sure this doesn't happen again. And I know we've taken a long time, but 6 years ago, I did an investigation when I was a minority or majority subcommittee chairman of an organization you might have heard of, Mineral Management Service. And what we discovered was they robo-signed everything they did practically, so there would be initials or signatures repeatedly, but they admitted to us in the investigation that basically they only saw the cover page and signed it. And so you had this look of accountability on oil leases that cost us tens of billions of dollars. You had this whole process of whether you had oversight in the Gulf over the quality of drilling rigs and so on. In 2006, we got a long way down there when we published a good report that said there was problems at Mineral Management. But we didn't take it to the next step. People died. Billions of dollars were lost. America was embarrassed. The oil industry was embarrassed. And lives were destroyed forever. Because in 2006, we knew there was a serious problem at Mineral Management, and we never did enough to try to fix them. Maybe BP wouldn't have happened if we'd seen it to its conclusion. In this case, these are human lives too, and we've got to take it to a conclusion that protects America in a way that I don't believe they're currently protected.
In reading the wiretap applications, I guess I'm confused. I don't understand how whoever read them wouldn't have been concerned with the fact that we're letting thousands of guns walk without any idea where they're going. Well, they had an idea where they're going because some were recovered in Mexico, some were recovered within the United States. But did you ever get an answer as to how that continued on for that period of time, particularly with, it's not like 7 guns walked, 10 guns walked, and we're trying to figure out who the bad guys are, because obviously in wiretap affidavit, they laid out specifically who they thought were involved, and were able to back it up through the wiretaps. And it wasn't 7 guns or 6 guns or 10 guns. It wound up being, in some cases, hundreds of guns in a very short period of time. Did we ever get an answer as to how that continued?
No, sir.
U.S. Attorney's Office is responsible for that.
Yes, sir.
Correct? Did we ever get an answer from the U.S. Attorney's Office as to where the ball dropped?
The people most closely associated with it have denied that the ball dropped. The people further away from it have said they didn't know, and that's part of the connect the two that we're trying to get to.
And so I go back to, my initial statement is, I can't imagine as the Chief Law Enforcement Officer under subpoena wanting to negotiate with you in regards to a specific area that you're concerned about as to what happened after the 4th, actually, when you got the letter, to the time they walked that back. Why would they stonewall you on that particular issue if they're clean hands?
I don't know.
Mr. Cummings?
I was sitting here thinking about, I'm going to answer your question. You're going to have to answer it again. But let me say something, because I need to get this off my mind. In my 61 years of life, no one has ever questioned my integrity, and you just did. And if we were in another setting, I would say you should take your words down. I'm not trying to protect anybody, and I resent what you said. I do, deeply.
You said what I said?
No, I'm talking about what he said a minute ago in answer to.
I answered a question.
Well, and I'm telling you, you questioned my integrity, and I resent what you said. Now, what was your question?
Well, I can see you were upset and you were stewing over there over that.
No, not stewing. It's just that.
Well, I mean, here's my question. You were an attorney. I was not.
Yes, I am.
I was a cop. But when presented with a subpoena, have you ever been presented with a subpoena?
Yes.
Did you?
But I'm not the Attorney General of the United States, and I'm not the person who asserts certain privileges, as Mr. Hastings was talking about.
does being the Attorney General of the United States preempt him from a lawful request from Congress, a subpoena, to produce documents? Does he have the ability just to say, I'm not going to do it, or I'm only going to do it to such a point as I want to, and after that?
Well, it's not as simple as you're making it sound. When you're asking me for wiretaps, if you're asking me, as Attorney General, for wiretaps, for things that are going to interfere with a investigation, for, let me finish, confidential informants, so it all depends. Or if you're asking me for things that might be subject to executive privilege, that's a whole other thing. So, and I think that's been part of what we've been going through.
Well,
that's a good answer, but I'll give you the other side of that answer.
okay, I'd love to hear it.
All we're asking for is every single responsive document that, in fact, would not compromise an ongoing investigation and would not be part of a court seal or some other prohibition. We can have a discussion with those separately. What the Attorney General has clearly said in testimony and through his employees and himself in that meeting last Tuesday is, no, I'm not going to give you any part of my deliberative process unless it serves my purpose of bringing this to a conclusion. Then I will give you a selected group after you agree to that. Ultimately, it is only that small part. We're not talking about wiretaps. We're not talking about things which a court would object to or that would compromise ongoing prosecutions. We're talking about things which we believe he has every right to give us, but he is saying that when it's deliberative, he will choose what we get or don't get. Meantime, that deliberation was about false statement made to Congress and the period of time in which they debated various aspects of it being untrue and what they were going to do about it. Now, Mr. McGovern objected to the reference to Nixon, but that's the definition of a cover-up. Something is said wrong to send people in the wrong way, and then there's a period of time in which you try to support a wrong statement. All we're asking for, and the reason for contempt is, we were told a lie. We want to know about the deliberation for 10 months between the lie and the truth, and that's the information we seek, and that's the information the Attorney General has said, no, I won't give you because it's deliberative and it doesn't serve my purposes.
One of the things that the Attorney General did say also was that he was protecting institutional concerns. You remember that?
Sure. His institution has the right to lie and then talk about it, is what he's saying.
See, this is what
Well, let me ask you, do you know what the institutional concerns are that he's trying to protect?
He
didn't go into that. He did not go into that.
But you know all we're asking for. The contempt is fairly straightforward here on the rule. It is, in fact, about documents during this period of time that would be responsive to the false statement made in February 4th of 11 until the time it was retracted. And I will say for all of us, and I know that Mr. Hastings and I had great service together behind closed doors, and we fought together against then the Bush administration when they didn't want to cooperate, and that was hand in hand up and down the dais. If we cannot have access to the information related that is necessary for us to do our discovery because it's deliberative, then in fact we have a closed government system in which we simply give them the money and go away. If we, in fact, cannot have, when we've been lied to, discovery about it, then where do we go to get the truth?
I thank both of you for your comments. Thank you.
Thank you.
Let me just say that we have 13 votes on the House floor, and I very much hope that we'll have a chance to hear